A Supreme Court decision didn't just affect gun laws. It quietly rewired how gun laws live or die in court. And that rewrite already changed 5 major gun law battlegrounds, without most gun owners even noticing. Quick question before we continue. Are you subscribed? Because what I am about to reveal could keep you from trusting the wrong headline and walking into a legal trap. Hit that button now. All right, here's what just happened and why it matters to you. For the last few years, most people thought the big gun story was carry permits, or assault weapon bans, or some new ATF move. And yes, those are huge. But the bigger story is something most people scroll past because it sounds boring. The Supreme Court changed the rulebook for how judges decide gun cases. That rulebook comes from a case called New York State Rifle and Pistol Association versus Bruen. In normal English, Bruen is the case that said, you can make regular people prove a special reason to carry a handgun in public. New York had a system where you had to show proper cause. That's basically, tell us why you need to carry, and we'll decide if your reason is good enough. The court said, no. The Second Amendment covers carrying in public for self-defense. But here's the part nobody talking about. Bruen didn't only change carry permits. It changed how almost every gun law gets tested in court. Before Bruen, many courts used a 2-step approach. Step 1, does the Second Amendment apply at all? Step 2, the judge weighs the law against the government's reasons, like public safety. The Supreme Court basically told courts to stop doing that balancing in the way they had been doing it. Instead, Bruen told courts to focus on text, history, and tradition. In plain English, the government has to show that a modern gun law fits with America's historical tradition of gun regulation. That doesn't mean there has to be an identical law from the 1700s. But it does mean the government needs real historical examples that are similar enough to justify the modern rule. Now, that sounds academic. It sounds like something you'd only care about if you wear a suit to work. But it has a very real effect on your day-to-day life as a gun owner, especially if you carry, travel, build, buy parts, or just want to avoid becoming a test case in someone else's lawsuit. Here's what just happened in a way you can actually use. I'm going to walk you through 5 gun law changes tied to Supreme Court decisions and the Supreme Court's ripple effects. Some of these changes look like wins, some look like losses, some look like nothing happened. But nothing happened can be the most dangerous outcome of all, because it lulls you into thinking the law is settled when it's not. First thing, public carry permits flipped nationwide, but the trap moved. Bruen's headline was about New York, but Bruen's impact spread across the entire country. Any state with a may issue system, where officials can deny you even if you pass the background check, got put on notice. Those systems became legally toxic, so a lot of states changed fast. People celebrated. They said, we won carry, we fixed it. But here's where people get fooled. Some states didn't just give up. They adjusted their strategy. Instead of saying, you must prove proper cause, they started saying, fine, you can apply like everyone else, but we're going to create giant lists of places you can't carry. And these are called sensitive places. That means places the state argues are so sensitive that guns can be banned there. And yes, the Supreme Court has said there are some sensitive places where gun bans can be allowed, like schools and government buildings. That's not new. The problem is what happened after Bruen. Some states took that concept and stretched it until it became a new version of may issue, just in a different outfit. So here's what changed for you. If you live in a state that responded to Bruen with big new lists of restricted locations, you might have a carry permit and still be walking into felony territory if you step into the wrong place without realizing it. Imagine you're doing normal errands. You stop for gas, you grab coffee, you run into a pharmacy, you go to your kid's school for a quick pickup, you swing by the post office, you meet a friend at a restaurant. In your mind, you're thinking, I'm legal, I have my permit. But post-Bruen, in some states, the problem isn't the permit. The problem is the map of where you can carry. And the worst part is that the map can feel totally random to normal people. It can be hard to tell when you were crossing from a legal area to a restricted area, especially when you're inside a building that has multiple uses. Here's a scenario you should picture. You're in a shopping center. There's a private doctor's office, there's a small government service desk, there's a daycare, there's a bank, there's a coffee shop, there's a restaurant, there's a pharmacy, all in the same shared structure. Now ask yourself, honestly, would you always know which part is restricted and which part is not in your state at that moment in time under the newest rules? Most people wouldn't, and that's why the Bruen fixed carry mindset is a mistake. Bruen changed the battlefield. It forced states to change, but it also pushed some states to use a different playbook. So that's the first gun law change that almost no one noticed. It's not just about who gets a permit, it's about where your permit actually works. Second thing, domestic violence restraining order gun bans did not collapse, and Rahimi changed how the history test is used. This is the part that shocked a lot of people who expected Bruen to steamroll every gun restriction. After Bruen, some lower courts started questioning long-standing gun restrictions. One of the biggest fights was about a federal law that blocks gun possession for people under certain domestic violence restraining orders. The simple version is, if a court has issued a qualifying restraining order against you that includes findings connected to threats or violence, federal law can ban you from possessing guns during that order. Then, the Supreme Court decided United States v. Rahimi. In Rahimi, the Supreme Court upheld that federal law against a Second Amendment challenge. The court's message was basically this: our tradition of firearm regulation allows the government to temporarily disarm people who a court finds are a credible threat to someone else's physical safety. Why does that matter to you, even if you're not involved in anything like that? Because Rahimi is the court explaining how Bruen's history and tradition test actually works in real life. A lot of gun owners heard history and tradition and assumed it means this. If you can't find the same exact law from 1791, the modern law is unconstitutional. Rahimi says it's not that simple. Rahimi shows the court is willing to accept historical analogies. That means older laws that are not identical, but similar enough in purpose and in how they operate. The court compared the modern restriction to historical laws that focused on people seen as threats, including old surety laws and going armed laws. Here's the big shift. Bruen made people think the entire game is about the object, like the gun itself. Rahimi shows the game is also about the person and the risk. Now, I'm going to be extremely careful here, because I don't want anybody misunderstanding this. Rahimi does not mean any law the government labels public safety will survive. Not at all. It means that when a law is targeted, tied to a finding of danger, and limited in time and scope, the government has a better chance to defend it using history. Here's a hypothetical example to explain this. Imagine two laws. Law A says, if a judge finds you are a credible threat to your spouse, you lose gun possession for the duration of the court order. Law B says, if you ever got a restraining order at any time in your life, you lose guns forever. Those are not the same kind of burden. Law A is temporary and tied to a finding by a court. Law B is permanent and broad. Rahimi is much closer to Law A than Law B. So what's the practical takeaway for you? If you care about gun rights long term, you have to pay attention to how courts are dividing laws into categories. The strongest cases are usually not the ones that rely on outrage. The strongest cases are the ones that clearly show the law is too broad, too permanent, too disconnected from danger, or too untethered from any real historical match. Also, if you've ever wondered why some gun laws survive after Bruen, Rahimi is a big part of the answer. It gives courts a framework to uphold some restrictions while still claiming they are following Bruen. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Third thing, bump stocks changed gun law without being a Second Amendment case, and that should scare you more than it comforts you. This is where most people get confused because they assume every major gun ruling is about the Second Amendment. Not true. Garland v. Cargill was about bump stocks. The big question was not, are bump stocks protected by the Second Amendment? The question was simpler and more technical. Did the federal government correctly treat bump stocks as machine guns under the law Congress wrote? The Supreme Court said no. The court focused on the definition of machine gun in federal law. That definition covers weapons that fire more than one shot automatically by a single function of the trigger. The court said a semi-auto rifle equipped with a bump stock does not meet that definition as written. Here's the most important part for you. The court did not say bump stocks are good. The court said, if Congress wants them banned, Congress has to write a law that actually bans them. An agency can't stretch words until people become criminals. That sounds like a win for gun owners, and a lot of people took it that way. But I want you to hear the warning underneath it. Because the real risk to normal gun owners is not always a direct gun ban. A lot of the real risk comes from how the government defines things. What counts as a firearm? What counts as a receiver? What counts as a machine gun? What counts as a silencer? What counts as a short-barreled rifle? What counts as readily convertible? What counts as designed and intended? Those definitions are where people get trapped. Here's a scenario you should imagine, because it's closer to real life than most people admit. You buy a product that is legal today. You keep receipts. You follow the rules. You don't do anything shady. Then an agency changes its interpretation and announces, we now believe this product fits a banned category. Destroy it, or surrender it, or face prosecution. Even if you hate bump stocks, you should care about this kind of case, because it's about how quickly a rule change can turn normal ownership into a criminal issue. Cargill is the Supreme Court signaling something to agencies. You don't get to create new criminal rules by stretching old words. That impacts more than bump stocks. It affects how future rules about parts, accessories, and classifications get written and defended. Fourth thing, ghost gun kits and unfinished frames got pulled deeper into federal control, And Bondi vs. VanDerStok tells you the government has more room than many people thought. If you only follow gun news through memes, you might think the Supreme Court always expands gun rights. Reality is more complicated. In Bondi vs. VanDerStok, the Supreme Court upheld a federal rule that treats certain weapon parts, kits, and unfinished frames or receivers as firearms under the Gun Control Act, at least in some situations. That's a big deal because it means the government can require things like serial numbers and regulated sales channels for certain kits designed to become functioning guns. Again, notice what's happening. This is not mainly a Bruen Second Amendment case in the way people usually talk about gun rights. This is another case about definitions and federal authority. And it changes the landscape quietly because it affects builders, hobbyists, and people who buy kits online. Here's what most people get wrong. They assume ghost gun means anything homemade is illegal. That is not automatically true everywhere, and the details matter a lot. State laws differ, federal rules differ depending on what the item is, how complete it is, and how it's sold. But the real-world impact is this. If you buy kits, unfinished receivers, or build parts, you need to understand that the classification can determine whether the item is treated like a firearm for legal purposes. So if you're the kind of person who likes to build, or you like buying parts and customizing, you need to watch this area like a hawk. Because this is where a lot of people accidentally become criminals. Not because they are violent, not because they have bad intentions, but because they didn't realize the legal category changed. Fifth thing, assault weapon bans and magazine limits didn't get resolved by the Supreme Court, and that non-decision is a major change all by itself. This one is going to sound strange, but stay with me. A lot of people expected Bruen to lead to a fast Supreme Court decision that would settle the big fights over assault weapon bans and magazine limits. That did not happen quickly, and in some high-profile moments, the Supreme Court declined to take certain cases. When the Supreme Court declines review, it does not mean they agree with the lower court's decision. It often means, not this case, not right now. Courts care about timing, case records, and whether a case is the right vehicle to decide a big national issue. But here's the part almost no one notices. When the Supreme Court says not now, the lower court ruling usually stays in effect. That means the ban remains in place in that state. It also means other courts can look at that ruling as a guide, even if it's not technically binding everywhere. So what changed? The change is that gun law became more regional and more confusing for longer. If you live in one state, you can have one set of rules. You cross a state line and the rules flip. And because the Supreme Court can move slowly, that mismatch can last for years. Here's the real-world travel scenario you need to picture. You live in a state where standard magazines are common and legal. You have a range bag. You have gear you've owned for years. You drive to visit family or attend a class or go hunting in another state. You pack like normal. You're not thinking about the magazine in the side pocket. Then you arrive in a state with a strict magazine limit. You get pulled over for a traffic issue. The officer asks questions. You answer honestly. And suddenly, your normal property is being treated like contraband. This is where consequences get real fast. Even if you beat the case later, the process can be the punishment. Lawyer fees, lost time, job issues, firearm seizures, stress. You don't want that. And here's a second scenario, also very real for modern life. You're a concealed carrier. You travel for work. You walk into a place you assume is normal, like a mall, a restaurant, a medical building, or a sports venue. Depending on your state and the newest rules, that could be a restricted, sensitive place. Or it could be a location where the default rule is no carry unless the owner posted a sign allowing it. That last concept is huge, and it's one of the ways states tried to respond to Bruen, flipping the default. Instead of you can carry unless posted, they try to make it you can't carry unless posted. That turns everyday life into a giant guessing game. And the Supreme Court's pace matters, because while the legal fight is still playing out, you're the one living under the current rules right now. So yes, the Supreme Court didn't decide the big ban cases can still be a major change. It means the uncertainty continues. It means the rules stay fractured. It means your risk depends on where you are. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe. Now, let's get practical. What should you do with this information? First, stop trusting single-sentence summaries. If you see a headline like Supreme Court upholds gun law or Supreme Court strikes down gun law, your next question should be, was this a Second Amendment case or a statutory definition case or an agency power case? Cargill and VanDerStok are perfect examples of why that matters. They affect your world even when they are not framed as classic Second Amendment rulings. Second, understand that Bruen is an engine, not a finish line. Bruen created the history and tradition test. That test will keep producing new results for years. Courts must compare modern laws to historical patterns. That means new carry rules, new location bans, new training rules, new insurance rules, and new permit conditions are going to keep getting tested. If your state passes a new carry restriction, the key question is, can they point to something historically similar in purpose and burden? Third, remember Rahimi when people say, Bruen means all prohibited person laws are unconstitutional. Rahimi shows the court is willing to uphold restrictions that are targeted and tied to dangerousness findings through court processes. That means future cases may turn on facts, procedure, and scope, not just slogans. Fourth, travel like the law is different because it is. Even if federal law stays steady, your risk changes the moment you cross a state line, especially with carry rules, sensitive places, magazine limits, and how states treat vehicles and hotel rooms. Here's a tip that sounds simple but saves people. Treat every trip like you're entering a new country with different rules, because in a way, you are. Fifth, start thinking in deadlines and updates, not in I heard it once. Gun law changes in waves, court decisions, injunctions, appeals, emergency orders, agency rules, legislative sessions. A setup that is fine today can become risky with one court order or one enforcement shift. And that's why you can't just watch one video and assume you're set forever. You need a system. You need reminders. You need updates. This information could literally expire after January 2026. Subscribe now because the next video explains exactly what you need to do before that deadline hits. Let's wrap this up. The key takeaway is simple. The Supreme Court didn't just change one gun law, it changed the playbook that decides dozens of gun laws. Carry permits, who can be disarmed, what counts as a firearm, what counts as an accessory, and how fast legal can become illegal based on definitions and court rulings. If you care about protecting your family and staying on the right side of the law, do not rely on vibes, headlines, or what your buddy said at the range. Subscribe, because I put in the hours so you don't have to. Final disclaimer in simple terms, I'm not your lawyer. This is general education, not legal advice. Laws vary by state and your situation matters. If you need guidance for your exact situation, talk to a qualified attorney in your area.